Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andrus. Today, I'm joined by my partner, Hillard Sterling, who's a shareholder and member of our litigation group. And Hillard and I have been working together lately on quite a few situations, which led us to discuss doing a podcast on how to handle disputes between members and or shareholders of a healthcare practice, how to handle it, how to deal with it, how to nip it in the bud. Hillard brings a lot of experience to this topic, so I'm really excited to have him with us today. Thanks for joining me, Hillard.
Well, thank you so much, Ericka, for having me. I'm excited to be on your podcast and talk about how we can reduce healthcare members' risks, which are prevalent, unfortunately, out there.
All right, so let's jump into it then. So we see all the time shareholders are fighting, members are fighting. How often are you seeing these type of disputes turning into litigation, real litigation?
The short answer is all too frequently. Um, Very often, healthcare practice members get into disputes, and it happens all the time, right? It's almost on a daily, if not weekly or monthly basis, where issues come up involving the practice, whether it be economic issues or personality issues or some combination thereof. The challenge really is when members get deep into the dispute and they try to negotiate and resolve the issues, but they unfortunately dig a deeper hole. They're unable to resolve it themselves, and they end up writing emails and texts to each other that actually intensify and magnify the problems. One of the sub-issues here is that anything that a practice member is sending to another member without the involvement of counsel, that's all discoverable. So what I see all the time is by the time the members realize that they can't fix their problem, they've already created a mountain of evidence that each tries to use against the other. And those are the emails and the texts that either win or lose cases. So the goal is to get involved with counsel early on when an impasse appears reasonably foreseeable, so that counsel can help manage the problem and also cover and protect the communications under the attorney-client communication privilege. So people are not writing exhibits that turn into evidence that is used against them.
I think that's a great point. And, I'm more of a corporate lawyer. So when people come to me, I'm trying to explain what do their corporate documents say. And I think one of the big issues is that, there's a role for your corporate lawyer. And that's not the same role that the litigation lawyer plays. And one thing I want to kind of clarify is that you need to also understand who the lawyer's representing, right?
Yes.
So if I represent a practice, I'm the practice's lawyer. I do not represent any of those shareholders or members individually. So what happens if I, as the corporate counsel, am included on all of these emails that you mentioned going back and forth? Can you speak to that and also speak to at what point the individuals need to have their own lawyers and what you see about people being unclear about those lines?
That's a great question, and it's a difficult one because the line is somewhat blurry between being a corporate counsel and then also being counsel representing individual members who are part of that entity. The challenge, of course, is when there's a dispute between the members, because then all of a sudden there arises a conflict of interest in which the corporate lawyer can no longer represent an individual member, because the goal as a corporate lawyer, of course, is to further and protect the interests of the entity in itself. If there's a breakdown within the entity, one of these individual members needs to consider retaining his or her own counsel so that they're getting guidance not just on what is protective for the entity, either an LLC or corporation, but what is protective for themselves. What should they be doing, not just to protect and further the company's interest, the practice's interest, but what do they need to do that's unique to defend their own interests? So typically, as you know, Erica, we work alongside each other in parallel fashion. Of course, it needs to be done typically in different law firms if you're representing the entity and the individual, because it's an ethical principle that a conflict of interest of one shareholder is imputed to all the other shareholders. So what that really means for practice members, physicians, and members of healthcare practices is if you see a dispute brewing and you know that the entity has its own lawyer, don't rely on that lawyer. Go seek independent counsel from another law firm to give you advice on how to protect and further your unique interests, which may or may not dovetail with the practice's interests and certainly often conflict with co-members' interests as well.
So, when does litigation then become necessary?
My general rule of thumb is if you see that an impasse is reasonably foreseeable, that's the time to hire counsel. And sometimes disputes are worked out by individual members. You can tell, and it's really a feeling issue as opposed to some sort of litmus test where it's easy to see one way or the other. But if you're a healthcare practice member and you are seeing yourself at an impasse with one or more of your fellow physician members, get counsel, because at that point in time, litigation is reasonably foreseeable, which raises all kinds of issues you may not know about. For example, if litigation is reasonably foreseeable, and those words are buzz terms in the legal industry, you are under an obligation to save all of your documents. It's a common law, judge-made document retention rule. So if you have a dispute with a member and litigation is reasonably foreseeable, and you're deleting texts and emails or modifying them in some way, you're trying to stack the evidence, you are engaging in conduct for which you and your counsel may be sanctioned down the line. You don't want that. Then all of a sudden the dispute turns into what they call a case within a case. It's no longer about the merits of your dispute with your partners, but whether you saved evidence, whether you modified evidence inappropriately. That's why, one of the many reasons why you need to get a lawyer if you feel I'm in an impasse, it's not working out. It doesn't mean you're going to litigate. In fact, the primary purpose of your counsel should be solving the problem. And frequently that involves trying to get a resolution before litigation. Maybe it's entering into a standstill agreement with the other side's counsel where everyone agrees we're not going to file suit, we're going to try to negotiate for a certain period of time. Or maybe we'll bring the dispute into a mediation and try to get resolution that way. So a lot of people don't want to hire lawyers because they think, oh my goodness, they're going to run into court. I'm going to be drawn into the vortex of a lawsuit for months or years with many thousands of dollars in attorney's fees. It doesn't have to be that way. An experienced lawyer is a problem solver, and that may be an early resolution if feasible.
All right. So let's say you do end up in court. What happens then? What are the, what's the legal process that would apply at that point?
Once you get into a lawsuit and it involves filing a complaint, that's the first part of the lawsuit. You are all of a sudden triggering a bunch of legal obligations and duties, including, of course, the need to preserve your evidence and your emails and your texts, but also the need to protect your communications as privileged. You should no longer be communicating with your fellow members outside of your counsel's presence. Again, that falls outside that scope of the attorney-client communication privilege, and you're just writing exhibits. And Ericka, I'll tell you, every case is won or lost on 5 to 10 emails or texts. That's the way of the world now. And an experienced litigator on the other side will find your emails and texts. Worse, you try to delete them, they'll find that out as well, and all of a sudden you have that case within a case. So when you file a lawsuit, your attorney files it, you need to preserve your documents and stop communicating. Go through your lawyer. Again, if your lawyer's experienced and has a lot of involvement in cases in his or her background involving these types of disputes, the goal is to get an early resolution. No one wants to spend unnecessary time and money in the litigation process unless it's absolutely necessary.
Right. And one thing I'll note is that a lot of times the answers, whether everybody figures it out themselves or you end up having a judge tell you, are in the corporate documents, right? So really just, if you agreed to something and you signed a corporate document, going to court to get a different outcome is not necessarily worth the time or money. Make sure your documents say what you want them to say, review them often, and follow them. Not choosing to, fight them, you know, when
Yes.
they properly negotiated and signed it is a way to waste time and money. But I mean, it's not something we recommend, obviously. But let's say that you absolutely cannot work things out. You're
Mhm.
going into court, you're fighting. How does this end up, aside from the fact that, you know, this person breached, that person owes money? How do we wind things up? How can things finally be resolved amongst the people in a business together?
There are really three paths toward a resolution, whether it be by settlement or by judgment from a judge or a verdict by a jury. The first one is the best, and that is a negotiated settlement. That's what everyone should be focused on, even while you're litigating. How do we get this case resolved? Because you don't want your fate determined by someone over whom you have absolutely no control. And judges sometimes they make mistakes, and if that happens and it's against your interest, then you're forced appealing it, and it's very difficult to get a judge's decision reversed. So, number one, try to negotiate an amicable resolution and a settlement. Number two, the other path forward, if you can't settle it, is try to dissociate the member who's causing you grief from the practice. Let's talk about the context of an LLC, which is typically or frequently how medical practices are organized under the as limited liability companies. Um, you touched on something, Ericka, that's so important, and that is follow your documents. And the main document with an LLC is the operating agreement. It just still astounds me after decades of doing this that a lot of practices don't have operating agreements, or almost as bad, they have operating agreements that they pulled off LegalZoom or just on some website where they found it on Google,
Or they
which
never signed it, or they
or
just
they
have,
never or they
right?
never signed it. That's right. I've seen disputes where you've had 5 or 6 LLC drafts go back and forth, and the parties just couldn't reach a resolution. What that means is they're not effective. It's as though there was no operating agreement at all. So um, my advice, my strong advice, is get a strong, solid, and clear operating agreement in place that pertains to your practice, not just practices generally. But talk it through with a lawyer. You can hire one lawyer to do the operating agreement for the entire practice if there's no dispute, so there's no conflict. Um, the second path that we were talking about, dissociation, that could be determined and defined in the operating agreement. So you don't have to leave it to a judge or some other source of standards to decide how and when people are dissociated from the practice. There can be fair processes in place. In addition to a settlement, number one, two, dissociation, the third path of a solution is dissolution of the LLC itself. Again, hopefully the operating agreement is there and it has clear terms on how dissolution occurs. If it doesn't, then you have to go to the Illinois LLC Act, which defines the processes for both dissociations and dissolutions. You don't really necessarily want to do that if you don't have to, because the LLC Act is broad, necessarily so, because it applies to all LLCs across the entire state. So there's a lot of room for disputes under the LLC Act on how dissociation or dissolution proceeds. The other reason why you want an operating agreement for dissociation or dissolution is to protect your own interests, so you get something at the end of the day. You get fair value at the end of the day if you need to part ways. You may not get fair value if the case doesn't have an operating agreement and the judge has to resort to the LLC Act. And that's really true with dissolution or dissociation because there is no right for a member to receive fair value or anything if a member is dissociated from an LLC. You don't want to take that risk if you're a member, and you know that at the end of the day, if things go badly, and they file a dissociation motion in court, you have no operating agreement, you may walk away with nothing.
And I guess, just like the dissociation process, um, if you don't have it in writing, the judge is going to determine their own way to achieve it. The same thing with dissolution of an LLC. Now, in most operating agreements, there's a process like first the debts are paid, then we value the assets, and the assets are split based on ownership, etc. So it's a nice pathway to resolving a dissolution if you have a document that spells it out. It's not always perfect, because when you're writing the documents, it doesn't necessarily think of all the things that may occur in 5, 10, 15 years, but it gives you kind of a path to follow. What happens, what have you seen judges do that may not be ideal if the dissolution process is not spelled out in an operating agreement? Are you seeing unfair outcomes, or is it just taking way longer than it needs to? What kind of things are you seeing?
All the above. Absolutely. It's almost inevitable it's going to take longer than you want it to, because you need to be checking in with the judge on how the process is unfolding. Well, as an initial matter, the judge has to set up the process, and there's a lot of arguments back and forth in terms of who are the members who are going to be involved in the dissolution process, what creditors are going to get paid, how are opportunities out there in terms of property that the LLC may own. How is that going to be sold? Who sells it? Who's going to decide if a sales price is reasonable? It's because typically LLCs own properties. In fact, some LLCs are set up just to own property. So there's all of those open and very difficult issues that often create more time, more burden, and more money for the parties in court. And there is no such thing, well, I should say, it's a rare thing to have a court process move quickly. Some judges are great at that, but the vast majority of judges have mountains of cases on their dockets.
Right.
Right, they're just trying to keep every case afloat and on top of it. So you shouldn't be relying and thinking about a judge as being your savior if you're having a dissolution, because that judge is focused on a lot of other matters, and there's a lot of disputes that are going to cause the parties to have multiple status hearings. It could take many, many months, if not a year or more, Ericka, for a corporate dissolution to work. And by then, the practice may be falling apart financially, and you're trying to save something that ultimately disintegrates by its own weight.
I think it's really important to understand the special assets of a healthcare practice as well. You have, the goodwill, the name of the practice, the phone numbers, the patient records. How can a judge possibly allocate those fairly among the members? And in most practices, patient records and patients belong to the practice, not to any individual doctor working in the practice. So when you think about it that way, the judge is looking at that as though they're just regular assets, not really thinking about, who thinks somebody in particular is their doctor, or what doctor thinks somebody in particular is their patient. And then you've got really well-trained medical staff or dental staff, whatever it is. So it's in everyone's best interest to really have a plan ahead of time, where you're absolutely right. The time it takes for a judge to rule, your practice has been destroyed. And, really the only thing to do would be to walk away. And one other thing I'll mention is that, let's say you say, I'm going to let the judge work this out. But in the meantime, I want to go practice medicine or dentistry or whatever it is. You can't solicit those patients. If there's a restrictive covenant that's in that agreement, that's a whole other issue. So where do you go? How do patients find you? Can you solicit them? How do you access the records? I mean, there's so many endless questions that just make this healthcare issue as it relates to dissolution so much messier.
You pointed out such an important layer to these disputes that we haven't touched on, also somewhat beyond the purview of a deep discussion, but it's so important to mention, and that's the implications of non-solicitation and non-competition provisions. Almost every practice has independent contractor agreements or employment agreements that have non-competes and non-solicitation clauses in those. And generally speaking, unless they're egregiously expansive in geography and or time frame, they're enforceable. And you're right, no one has ownership of the patients. So that belongs to the practice. So physicians just can't leave and start their own practice because of those non-competition and non-solicitation clauses and this principle that they don't own the patients. The practice does. It creates this whole tangled web of issues that needs to be unraveled and sorted through in order for the members to figure out, okay, how are we going to move on with our lives? And how are we going to do so in compliance with our contractual obligations to each other? You know,
Yeah,
go ahead.
imagine, if I'm wrong, that during that, what could be a year-long process of dissolution, that the judge is not going to look kindly on somebody who just throws out those prohibitions and starts doing what they want. So you're really frozen in terms of your hands are tied during that period, correct?
Correct. It's another reason why counsel needs to get involved early. If practice members are trying to do self-help and they want to continue their practice outside the scope of the entity, they're almost certainly likely going to be running afoul of these non-competes. And as you mentioned, Ericka, judges don't take kindly to that. And in fact, there's a lot of cases out there enforcing injunctions against physicians. So the ideal scenario is to get each side to have counsel talking with each other to negotiate some standard and some foundation for how the parties are going to behave with each other until the issues are wrapped up. There's a way to allocate the patients, at least on an interim basis, to decide how they're going to protect their intellectual property, the patient list, the confidential information. The other thing I'll mention too, Ericka, is people may think, oh, I don't have a non-compete in my employment agreement, or I'm going to go more than, say, 5 miles, which is my radius in the employment agreement. The question I have is, have you looked at other agreements that you may have signed in connection with the practice that may have even broader and wider non-compete provisions? For example, if you have invested in entities that are associated with the medical practice, those entities may have their own operating agreements in which you're a member and you need to comply with those. And generally speaking, judges enforce those operating agreements even if they have expansive restrictions, because it's in a business context as opposed to an employment context.
Right.
So enforced
Yeah.
more expansively by judges.
So one other thing I want to mention is we talked about disputes, and certainly it helps to have an agreement that everybody can follow. But if you don't have a written agreement, you also can not have guidance on how to handle a member of your practice who might die or become disabled. So, what you and I have seen is disputes with families, um, over disabled members or their estates. And all of this as well can end up in court and can be avoided by making sure that you have documents that spell out the particular rights and duties of each individual. For example, typically you have to be licensed to own a dental or medical practice. So the document should make it very clear that upon death or total disability, the corporation gets that ownership, or the LLC gets the ownership back. What it's paid for, how it's paid for, should be spelled out as well. But if you don't have that document, we often find that the family can be uncooperative, or they're just willing to spend the time and money to fight about it. And even if the court eventually decides the right way, how many months, how much money has been spent? So having the document really helps avoid some of that as well.
Absolutely. A little investment up front could save a substantial amount of money and time and pain and burden in the long run. So what you're saying speaks very loudly and wisely to the importance of getting the foundational documents in place so that they're clear and they contemplate all these different scenarios that may affect the practice or cause it to stumble, so that the parties have some way out. And the other thing you mentioned that we didn't touch on, but it's important, you have to be very careful that a member of your practice and maybe independent contractors who are part of your practice are licensed physicians and are not engaging in what may be characterized as the practice of medicine, because that may run afoul of Illinois statutory law and threaten the entire existence of the entity. So that's another reason to have counsel involved up front to write the right documents and make sure that the right people are involved in the right places with the entity to avoid those potentially dispositive problems.
Perfect. I mean, we could go on and on. I think the basic summary here is have documents, get them done properly, get them signed, review them often to update and make sure you understand what's in there. Make sure you have good corporate counsel. Make sure your corporate counsel understands their role. And if there is a dispute, get your own counsel, I think is probably the summary of what we've talked about, right?
Those are the takeaways, absolutely. And from anyone who wants to see the risky territory, if you don't do those things and you don't protect yourself through documents, go on Google and look up Illinois LLC Act dissociation or Illinois LLC Act dissolution and read the statute. And you'll see, do I want that statute governing my scenarios, my paths, and my risks? And the answer will be no. And that's why you really do need to think about the potential problems up front and get the right documents in place, including, of course, that ever important operating agreement.
Perfect. Or shareholders agreement, right?
Shareholders agreement if it's a corporation. Absolutely.
All right. So any final thoughts? I think for me, that's pretty much covering everything.
That really wraps it up, Ericka. But my general theme here, adding on to yours, is get ahead of the problems early and make sure that if things are going sideways, stop writing documents, stop writing emails and texts, and consult with counsel to make sure you're doing the right thing, and maybe get counsel actively involved to try to help you solve the problem. That's what real experienced counsel try to do, and that's solve rather than litigate.
I agree, absolutely. All right, so if anyone has any questions, they're having a dispute, they're worried about having a dispute, they're not sure their operating agreement or shareholders agreement gets the job done, feel free to reach out. We're happy to help you talk through these issues, make sure you're in good shape. And again, this has been Hillard Sterling as my guest, and this is the Health Law Hotspot. So thanks for joining us, and we'll see you next time.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.